Hi, this is attorney Andrea Witt.
And I'm attorney Stephen Spano with a Legal and Financial Minute, or two. In this episode, we're going to discuss a crucial topic that many people overlook: how to properly safeguard your will while keeping its contents private.
That's right, Stephen. It's not enough to just have a will. You need to ensure it can be easily found and accessed when the time comes. Otherwise, it will be presumed that you died without a will, and your home, money, and belongings may go to someone other than those you love.
Exactly, Andrea. We just had another client whose father passed away. The family knew he had a will drafted by the family lawyer, but the family lawyer did not keep a copy, and the family cannot locate the original, though there is a safe deposit box that has the father's name on it, but only the father's name. So it may be in there, though that presents another problem.
This situation is more common than you might think. So let's break down some options for safeguarding your will while keeping its contents private.
You can store it with a law firm if they offer an option to maintain your original documents, as we do. A law firm with multiple attorneys, a succession plan, well-developed systems, and professional practices is likely to have an option to safely store your original documents, including your will. A single attorney firm, however, or one without a succession plan or well-developed systems, is definitely not a desirable choice for storing your will and other original documents.
Another option is to keep the will at home. If you choose this route, make sure it's in an accessible location, easily identifiable, and protected from spills and damage. We provide a fully enclosed case with our firm name to help those you love to locate and easily identify your will and other important documents.
And we learned that the hard way, because the way we used to provide them, people would spill things on them and damage them. Well, here's how it becomes tricky. Some people think a bank safe deposit box is the best place for a will and other important documents and put them in there. However, while it's secure, it can cause some significant problems.
That's certainly right. In Massachusetts, if you're the only person named on the safe deposit box and you pass away, the bank won't allow anyone to access your box without proper legal authority issued by a court.
Proper legal authority. That means your family will need to go to court to obtain that authority. They do this by petitioning the court for the appointment of a special personal representative for the limited purpose of gaining access to your safe deposit box, just to search for your will. They cannot touch anything else in the box.
To avoid this complication, if you do use a safe deposit box to store your will and other important documents, make sure to add a trusted person as a co-owner. This way, they can access the box without the legal hurdles and expense of going to court for authority.
The moral of today's episode is that it's not just about having a will, it's about ensuring that it can be found when it's needed, because you're not going to be around to help anybody.
Absolutely. Take the time to think about where you'll store your will and who will be able to access it. It will save your loved ones a lot of stress, potential legal complications, and a lot of money.
We look forward to sharing more practical, legal, and financial information with you in the future. Watch for our next episode of A Legal and Financial Minute, or two,
where we will continue to provide you with information to help you and those you love to protect your health, your assets, your income, and preserve your way of life.
If you have any questions or topics you would like us to address, call or text Spano, DeWicki, and Witt at 781-231-7800 or email us at help@spanodewicki.com. Thank you for joining us.